Hi everybody, Tom here. There's something about the Irish Constitution, a feature, that I think you should come to appreciate and understand right from the beginning of your engagement with the Irish Constitution. And that is that our Parliament, the Oireachtas, while it enjoys, as you know, sole and exclusive authority to make laws for the state, is blocked from making a law that would be or might be in any sense inconsistent with any of the provisions of the Irish Constitution. So in other words, our Parliament isn't supreme, I suppose. Our Parliament doesn't enjoy absolute sovereignty. There is this limit, this express constitutional limit on the authority of the legislature to legislate. Now, there is no such equivalent provision, let's say, or block on the Parliament at Westminster, for example. Right, so this marks a somewhat distinctive feature, or a distinguishing feature for the Irish Oireachtas, Irish Constitution, and several other constitutions around the world. There is a corresponding, that's a limitation, you might say, on one of the organs of state. There is a corresponding extension of authority to the courts. That is to say, the High Court, Court of Appeal and Supreme Court are vested with the authority expressly in our Constitution to invalidate laws that they, the judges, deem to be inconsistent with a provision or the terms of the Irish Constitution. That's sometimes called in the literature judicial supremacy. In other words, the judges enjoy the final word as to whether a piece of legislation is constitutional or otherwise, and if they find it unconstitutional, once they do, and once they issue that declaration, if you like, in a case, that means that that provision of legislation is invalid. It's null and void from that moment, if you like. In other words, judges can issue what's sometimes referred to as a judicial death certificate to a provision of legislation. Now, there are two provisions of the Constitution that you should bring your attention to, I suppose, in this context. The first is Article 15, Section 4. Now remember, the provision of Article 15 that you all know very well is 15, Section 2, subsection 1, sole and exclusive authority to make laws for the state. A couple of sections afterwards, or subsections afterwards, you have 15, Section 4, which is really a very simple provision, although it contains two subsections, each of which you should kind of read and come to understand the phrasing, the wording, the implications, and so on. And then, correspondingly, in Article 34, Section 3, concerning the judicial power. Remember, Articles 34 through 38 of the Constitution, if you recall from our map, have to do with judges, the administration of justice, and the courts. And there's a provision in there that says simply that the jurisdiction of the High Court extends to, or goes as far as, or includes the authority, the jurisdiction, the power to invalidate, to strike down legislation. Well, imagine, for example, that the Irish Oireachtas enacted a piece of legislation that included a provision which made it an offence to assist another person in the act of suicide. Euthanasia, a legislative, an absolute ban on euthanasia. Now, as you probably know, there is such a ban in Ireland under the Suicide Act of 1993. There was, as it happens, a challenge in 2013 taken by a woman called Marie Fleming against that provision, arguing that it was unconstitutional, and as it turns out, she lost her case, and lost in the High Court and on appeal to the Supreme Court. So she was not successful. That law remains on the books. But imagine that Marie Fleming were taking her case, rest in peace, were taking her case in the 2020s. What it would mean, I suppose, is that she would be arguing that this absolute ban breached her personal rights under Article 40 of the Constitution, her autonomy, her dignity, her freedom of conscience, maybe her equality, for instance, given that suicide is not a criminal offence in general, and so therefore able-bodied people can, as it were, die by suicide, whereas people in her situation cannot, because they're physically incapable of doing so, if you like. Now, she could, and as it happened she did, and her lawyers did, make a very good argument in the courts as to why the absolute ban breached or violated Article 40 of the Constitution. If she persuaded the judges of the merits of her case, well then, the judges would or could certainly ultimately invalidate that provision of the legislation, rendering it null and void. More mundanely, imagine if, for instance, the Oireachtas passed a piece of legislation, presumably in a finance act, that imposed or had the effect of imposing a higher income tax bill on a married couple than those individuals in that marriage would pay if they weren't married. Now that would, I think, violate Article 41 of the Constitution on marriage and the family. In other words, if you were in such a relationship and that were the case, and it was a big deal to you, cost you a lot of money, and you took a case in the High Court, you would probably win, I think, which would mean that from that moment that the judge issued her decision, that provision of legislation would be null and void, dead. Now, there's an interesting question, of course, if that were to happen in 2021, and the provision had been on the books, statute books, since 1971, well, if you look at the text of Article 15, Section 4 of the Constitution, that tends to suggest, does it not, that the provision always had been, or had always been, unconstitutional, if you like, this provision of the Finance Act that had this effect. Now, that would have huge implications for the Exchequer, because all of that tax by all of those married couples over all of those decades would have been collected in breach of the Constitution, if you like. So what happens in that kind of scenario? That's an interesting question we explore in the module, if you like. So there you go. That's something that's quite distinctive about, or not distinctive because it's a feature we share with the US, for instance, Germany, and many other constitutional democracies. But it does mean, doesn't it, if you think about it, that our judges enjoy a great deal of power in this democracy. What I mean by that is this: our legislature comprises 158, depending, 160 or whatever, members of Parliament. Our Dáil Éireann has 158 members, each of them elected by thousands and thousands of people around the country, and therefore they enjoy that democratic mandate, if you like, that democratic authority. And they, over time, deliberate on, consider, revise legislation. Right? And then so this legislation is enacted by this institution that enjoys enormous democratic authority, if you like. And 6 months later, or 6 years later, or 60 years later, or whatever it might be, an individual judge, sometimes sitting on her own in the High Court, can hear the arguments brought by the litigant and can invalidate that piece of legislation, take it off the books there and then, in that moment. And that's pretty significant power. If you think about it, the UK judges do not enjoy that power. Canadian judges don't enjoy that power. New Zealand judges don't enjoy that power. And several other judges around the world don't enjoy that kind of constitutional authority. So that brings into play then this kind of interesting questions around how the Irish judges have exercised that authority. They don't want to exercise it too readily. They appreciate the difficult task they have, the significant responsibility they have. So they have developed certain doctrines over the decades. The doctrine of proportionality, for instance. It cannot just be that a piece of legislation interferes with an individual right. It must be that it interferes and places a disproportionate burden on an individual right. The presumption of constitutionality, and so on. So we will explore those doctrines, but really also explore that kind of dynamic between, after all, two of our organs of state, the judicial branch, the judicial organ, and the legislative organ. So they're the two provisions. Article 15, Section 4. Remember it, revisit it, read it, internalize the text, if you like, and Article 34, Section 3.